Thank you, Deputy Speaker. Colleagues, I rise today to speak against this legislation. I think it's poor law. My constituents have written to me asking me to speak against it, and on a personal note, I think, as the previous member for Cowan has said, it's disproportionate. In fact, I'd go so far to say it's cruel. And I ask the government and my colleagues on the government side and in the Senate to really reconsider this support for this legislation. And for three reasons. It's poor law, it goes far too far, and it won't achieve its results. As the member for Cowan has so well outlined, the Senate inquiry, the Senate Committee into Legal and Constitutional Affairs has done a report, and I won't repeat the recommendations that you've so clearly outlined. And as you remember, the Law Council of Australia has made some very clear recommendations, so I won't cover that ground. What I'd like to do today is bring the voice of my constituents to Parliament, people who have visited the immigration centres and have written to me about this. So this is the voice of real people in real time. And the major problems that they have with this proposed legislation is the banning of mobile phones and the ridiculous suggestion that we revert to landlines, the blanket treatment of all detainees as criminals, and the minister himself says that 25% of the people in the whole detention centre are there as non-criminals. The excessive power it gives the minister, as outlined. The use of detector dogs, so distasteful, and the subtlety of changing the names of the transition accommodation centres. We're now going to call them all immigration detention facilities. And I think it's in that name alone that we get a sense of what the government is trying to do here. So it gives me great pleasure to bring the voice of two of my constituents to Parliament. One is an individual, Freda Andrews, who's a regular visitor to the detention centres, and the other one is from Rural Australians for Refugees, who have made a submission into the inquiry. And I'd like to put on record why they think this legislation is particularly onerous. So Freda writes to me, "Cathy, I'm writing to advise you of changes that have occurred to visiting regulations and procedures at the detention centre at the Melbourne Immigration Transit Accommodation, MITA, in Broadmeadows. I have been visiting detainees in MITA since 2005 and have continued to remain in contact with them, and both those who remain in detention and several who are now on community detention. So she's got real skin in the game. And she outlined some of the areas where she's got particular concerns. So, movement of detainees. She says that all outside activities were stopped. Accommodation was segregated into separate units for men, women and families. Detainees were not permitted to mix with each other without making an application in writing. This meant that the only time they were able to mix with others held in other accommodation units was in visitors' rooms. And if they were required to attend outside appointments, these people with no criminal charge, no sense of anything wrong other than seeking asylum, they were accompanied by guards, and video surveillance and handcuffs were also used to monitor them. Freda also talks about visiting regulations. So she's a visitor from North East Victoria, travels to Melbourne to visit these detainees. Applications to visits continue to be accepted by phone or email. However, the number of detainees that could be visited has been significantly reduced. Session times were changed, with the first one being brought forward to 1:30 p.m. Freda says this presented some difficulties for me in terms of coordinating train and bus travel, particularly as the rule was that if you arrived more than 30 minutes late, you were refused entry. Now, everybody who uses public transport in North East Victoria knows about our abominable public transport system and how it's more frequent than not than the train is late. And no exemptions were permitted. This also applies to detainees, Freda tells me. If they were not in the visitors' room within the first 30 minutes of the visiting session, they were and are refused entry. And only food that was to be consumed in the visitors' room was permitted. She talks about gifts to detainees. And this is a common practice in rural and regional Australia, that when we visit people we take gifts. and traditionally gifts from my community have been gifts of food, fresh food, well-grown in our gardens. So Frida says that regulations in regard to food were again heightened in October 2017 and still apply. Food that can be taken in is limited to that which is commercially packaged, labelled, factory sealed and has a visible expiry date. So no fresh food at all. So what is that saying? That we farmers don't grow good food, that we won't accept good food? I had the opportunity to talk to the minister about this last night, and he said, well, we do it for security reasons. And then that just points out to me that security reasons, we're just going so overboard. Surely fresh food can be checked if it needs to be. It doesn't have to be wrapped up. And we certainly don't want to take packaged food in. So Frida also talks about the opportunity to leave a gift for a detainee became extremely difficult. So this could have been clothing, shoes. The detainee must first make a request in writing, which is then submitted for approval. If approval is granted, leaving the gift for the detainee becomes a significant challenge. The gift can only be left at reception at restricted times, e.g. Tuesday, Thursday or Saturday between 9:30 and 11:30 a.m. And Frida says this makes it almost impossible for people like myself, who travel a considerable distance to visit, to leave something that has been requested or as a gift for a detainee. Why would we make it so hard? Frida talks about applications to visit must be made by email, and she details all the rules there. And she talks about how particularly difficult that can be. She's concerned for the families and friends of people held in detention who visit them, so not only visits from my electorate, but their family and friends, who may not be able to comply with the requirement being reinforced from January 22nd. So not everybody has access to a computer or a device that enables them to make an online application. Not everyone has the standard of English, being able to read or understand the complicated application forms. And not everyone has the necessary 100 points identification that you need to become a visitor. So we've made it absolutely erroneous, and everybody knows the benefit of visitors and why it's so important. Why have we made it so hard? Frida goes on to talk about a whole lot of other problems, but that's probably enough just to give you a sense of how cruel and inhumane these rules have become, and how we've worked against what surely is the objective of supporting people in detention, keeping them sane, building community connections, making it so that when asylum is granted, they can move into the community with good relationships. So we are absolutely working against that. And I'd like to now turn to some of the points made in the submission by Rural Australians for Refugees. Rural Australians for Refugees has over 70 branches throughout Australia, consisting of people living in rural communities who support people and those seeking asylum. And many of the members of Rural Australians for Refugees travel significant distance, many on public transport, to visit people in these transit accommodation centres. So just to take a few minutes to talk about some of the issues that RA sees. And I totally, on a personal level, agree with this. That the RA submission says immigration detention is ideally for administrative purposes. So it's really important that we've got the opportunity to put people in transit camps while we sort things out. But it shouldn't be punitive. And if it is going to be punitive, if we decide that, then we have rules and regulations that must be followed. And they are Australian rules and they've been hardly fought. And my sense is that in these particular provisions before the House today, we are ignoring the well-fought rule of law. So many people feel, and I agree, that the conditions that we are imposing on these detention centres are worse in many cases than what we have in prison. The lack of a time limit on detention, and we have limited oversight of detention. So the lack of time limit of people are there, and the actual attention to the people's case remain two big areas of concern for rural and regional, rural and RAR. According to the latest departmental statistics, RA says as of 31st of July 2017, the average length of detention is 442 days, with 22% of detention population 22% spending more than 2 years in detention. No trial, no sense of guilt, just by force. Ra also says the number of children in onshore detention facilities has dropped, but there's still no legislation to prevent the detention of children, resulting in concerns that this bill could also impact on children. Ra talks about the explanatory memorandum of the bill and the narrative justifying why we need to do it. But the narrative doesn't talk about the people who have legally and properly and rightly sought asylum. These are not illegals. It's their right for asylum. And the bill fails to protect the rights of all these people, this group, and requires them to face the same restrictive measures for those who might have committed crimes and are assessed to be at high risk. Sure, they might be in detention centres, but putting everybody in the same basket is just grossly unfair. The Ra submission talks about the Minister for Immigration's wide-ranging discretionary powers in relation to people's visas and detention which already exist. And they say that there's no limit or no option to review and challenge these decisions. And the bill seeks to grant the Minister yet more discretionary power to declare any item a prohibited thing and prevent people in detention and their visitors processing prohibited things. And we've got a list of them here, including a mobile phone, heavens above, and we've given the Minister power to do more, and not to come to Parliament and do it more, but to do it by regulation. So Rural Australians for Refugees is concerned about the discriminatory policy which allows some in the immigration detention centres to have access to mobile phones, while at the same time not allowing people who have come by boat or asylum to have them. So they continue. And just to pull out a few items which I just can't see how members of Parliament of goodwill could accept this. The explanatory memorandum also mentions visits from family and friends as a way of ensuring people in detention maintain contact with their support mechanism. Of course, but our members of Rural Australians for Refugees report increasingly difficult for families to access detention facilities, constantly changing rules and their inconsistent application, challenges to securing a visit and getting through the screening process makes it really difficult for visitors to pursue. Rural Australians for Refugees understand that the ABF plans to implement further restrictive policies regarding the number of people a visitor can have to see. Like, why make it so hard? So my sense is that I don't understand where we're coming from with all of this. Why treat everybody the same? Why make it really difficult? Why say we as a nation need to be almost bullying to get the point of view across? So the bit that really upset me, I suppose, as I was reading about the powers that we're going to will pass through this House, and I do hope will be stopped in the Senate, is the use of detector dogs. Like, there's not many people in Australia who would forget the image of those dogs at the big union demonstration on the wharf a few years ago, and the horror it produced in our hearts as we saw the dogs on leash being brought by police to attack unions. And as a nation we said, no, we don't do that. Yet we're going to allow these detector dogs into immigration centres where people have been traumatised, abused, no warrant required, no oversight required, no reporting required, and no conviction from these people. So, in closing, my call out is this is bad law. It's over the top. It's cruel. And I say it's not the Australian way. We are much better than this. Minister, you are much better than this. Prime Minister, you are much better than this. Your government is much better than this. And the people on the government side, can I sincerely ask you, before you vote on this legislation, to actually check in with what you're doing, because I will hold you to account. Rural Australians for Refugees will hold you to account, and the Australian public will hold you to account, because this is very bad law.